In today's Supreme Court news, we discuss the cases involving Twitter and Google as it relates to Section 230 protections for being publishers for their own algorithms. So, this has been a bit of a variant on a theme. We know from the law that Twitter and Google and other social media are not responsible for the content that other people post. That's Section 230. Other people's creations are the responsibility of those people, not the responsibility of the platform, which is also good for me personally, by the way, as a YouTube creator, because I'm not responsible for the things in chat, which is nice because I'm not the creator of those things. So YouTube isn't responsible for me. I'm not responsible for my chat. Twitter's not responsible for the tweets. It's the law. All right. So, but there was a question as it relates to Google and Twitter's algorithms, because the algorithms might promote or recommend content. For example, you watched a video. Would you like to see this video? You liked this tweet. Would you like to see these tweets? And maybe that is different because now it's Google or Twitter or whomever that is acting to create something, promote something. Are they now the author of something? Are they now the publisher of the thing rather than just the platform thing, the thing, because of their own algorithm? This was the issue, and this case has been decided in both Google and Twitter. We will cover the summaries of both. So let's go ahead and get started with this. Starting with the Twitter case. In 2017, an individual carried out an attack on a nightclub in Turkey on behalf of ISIS, which is, of course, a designated foreign terrorist organization under US law. The family then brought lawsuit under the Anti-Terrorism Act that permits a US national who's been injured by reason of the international terrorism to bring suit for damages. So the United States has a law that says, hey, if you're a US citizen or a US national and you've been injured by the terrorism anywhere in the world, you can bring a lawsuit in the United States because you're a US citizen, right? And we love you. So you can bring a lawsuit no matter where it happened, anywhere in the world. So the fact that this happened in Turkey, we don't care. You're a US citizen, you can sue for the terrorism in US courts. So go ahead and do that. Now, instead of suing ISIS themselves under the relevant law, the plaintiffs invoked a different provision of the law to sue social media. So we could obviously sue the terrorists. We could sue ISIS. Now we want to know, can we sue social media? So we're trying to sue Facebook, Twitter, and Google for aiding and abetting, right? They are responsible for aiding and abetting. They have facilitated the terrorism, so they're just as guilty. Also, they're a little bit easier to find. Also, they have bigger pockets. But we're going to try to get them under the idea that they facilitated through the social media, allowed these terrorists to do their terroristic things because they DM'd each other on the Twitters, or they coordinated, or they did things and Twitter knew about it. That's the idea. The parties today agree on basic aspects of the platform. So there's agreement of a lot of facts. Billions of people from around the world sign up for the social media and upload massive amounts of content. Defendants profit from the content by placing ads on or near the content and use recommendation and matching algorithms to base users to the content and the ads. So we'd like to, increase the amount of time people use our app. So we are going to use algorithms to find content that people like. And also we'd like the ads. So we're going to find ads that the users will like that goes well with the content so we can maximize our value. So we have these algorithms in place to match users to the content, match users to the ad, match ads to the users, so forth and so on. We've got all that going on. As parties represent things, the algorithms here match any content with any user who is more likely to view the content, and the platforms perform little to no upfront screening. So the algorithm is doing a whole bunch of stuff behind the scenes, trying to find the content that we think that you'll like. The plaintiffs allege that for several years, the companies have knowingly allowed ISIS and supporters to use platforms and these recommendation tools for the purpose of recruiting, fundraising, and spreading propaganda. So the idea here is that Twitter Facebook, Google, whomever, know about this when it comes to ISIS and are not doing anything about it. They're allowing ISIS to spread their message, coordinate their messages, DM each other, all that stuff. And they're not doing anything to prevent it. The plaintiffs further allege the companies have, in the process, profited from ads relating to this. So there's ad matching for everything, and we found some ads and we gained some money, perhaps from the ISIS content, is some of the things we've done. All right. The district court dismisses the complaint for failure to state a claim, but the Ninth Circuit reversed. Okay. So assuming all those things to be true, because they agree on them, assuming all those things to be true, can you sue the social media companies for aiding and abetting? That is the specific theory we're trying to do this, right? Aiding and abetting international terrorism. There's a specific law we're trying to invoke here. There's a law that says if you're responsible for the international terrorism, you can be sued by a U.S. citizen, no matter where it occurred, if the U.S. citizen was injured. You can be sued everywhere, universal jurisdiction for these things. And so the question is, by all that stuff, did the social media companies aid and abet the international terrorism in a way that performs liability for them? So let's see what the Supreme Court says. The Supreme Court says the plaintiff's allegations that the social media companies aided and abetted terrorism fail to state a claim. So no, not so much. This does not fall within that definition. They are not aiding and abetting terrorism through their actions. So to reach that conclusion, let's discuss why. In 2016, Congress passed a law that would impose civil liability on anyone who aids and abets by knowingly providing substantial assistance or who conspires with a person who performs an act. So this sounds a lot like standard aiding and abetting under criminal law. Knowingly helping. You have to know that you're helping, right? This is the difference. This is one of the ways, by the way, that just not everyone gets swept into criminal conduct. You know, a guy comes to you to do a thing. It's in the nature of your business to do the thing. But the reason the guy is doing it is for criminal purposes. But if you don't know that, you didn't break the law, right? So, you know, the guy comes to your shop to rent a car. You're in the car rental business. The guy would like to rent a car. But little did you know, he's renting the car to get away from the police because he just robbed a bank. But you don't know that. So you're not aiding and abetting because you don't know that this guy's a criminal. You have to have some knowledge that you're facilitating a crime of some variety. So it's like, I had no clue. If that's true, then no liability. So this language sounds pretty correct for aiding and abetting law. You knowingly provided assistance. You conspired. That sounds about right. The question here is where this is that. Did the social media companies do the thing we just described? Did they knowingly provide assistance? Did they conspire? Is that what they did? The text of the relevant law begins with two questions. What does it mean to aid and abet? Good question. And what precisely must you do to aid and abet? Also a good question. Nothing in the statute defines any of the critical terms. Aid, abet, knowingly provide substantial assistance. So they don't define those terms for the statute itself, which they could obviously do. That's less a problem here than it might be in other statutes because these sort of terms have more well understood meaning. So fine, you didn't want to define those terms, no problem. So we'll just use standard definitions because we have a pretty decent idea what those things mean. The term aid and abet is a familiar common law term, so brings a whole bunch of stuff with it. We don't necessarily have to define it because these terms are defined. If you want to define it, that's fine. You can, but you didn't, so fine, we'll just use the standard definition. Congress also provided additional context by providing a legal framework for civil aiding, abetting, and conspiratorial liability. The legal framework, when viewed in connection with common law, therefore defines aids and abet and confirms it to have the normal meaning: conscious, voluntary, culpable participation in other wrongdoing. In other words, you got to know. You got to know it's not just enough to have a car rental facility that people buy cars from or rent cars from. It's not enough to have a shredding business that shreds papers and people bring papers to shred that they're not supposed to. You got to have some knowledge. If you're just a business doing business in the ordinary course of business, that's not enough. In the relevant law, the DC In the relevant law, the DC Circuit undertook an extensive survey of common law with respect to aiding and abetting, and therefore defined aiding and abetting this way. There must be a wrongful act causing injury performed by the person who the defendant aided. So if I aid you in your crime, it has to harm you in order for you to have standing. So first of all, you have to have been hurt. Otherwise, why are you here? At time the assistance was provided, the defendant must have been generally aware of his role as part of an overall illegal or tortious activity. So it's not necessary that I know exactly what crime I'm facilitating, but I gotta know that I'm doing something wrong. So general knowledge that something is wrong in the state here. And defendant must have knowingly provided the assistance. So, if I didn't knowingly provide the assistance, because, I just have a big bin somewhere for people to dump documents, then maybe that doesn't count, right? The court then articulates 6 factors to help determine whether the assistance is substantial. So I've got to do something meaningful. Okay, what does it mean to be meaningful? The nature of the act assisted, the amount of the act assisted, whether the defendant was present at the time. If I'm not there, less likely that I aided and abetted. The defendant relation to the actor and defendant's state of mind and duration of the assistance. So how much did you do? How much did you know? Was the bad guy there at the time? These are kind of factors we can look to. The law clarifies that those who aid and abet the act must not also do it for the act itself, but also for reasonable acts done in connection. So again, I just have to have some knowledge of what I'm doing. So if I know that I'm doing X, but also Y is also true, then if Y is foreseeable, I'm liable for that too. That also is pretty standard as it comes to conspiracy accessory law, by the way, right? If I join in conspiracy with you and then you do an extension of the conspiracy, I am typically liable for the extension of the conspiracy as long as it was foreseeable as part of the conspiracy. So the question would be, so I join in with a conspiracy. You do things that are clearly within the scope of the conspiracy. Now you do something that's illegal, that's outside the conspiracy strictly. All right. So is that a separate illegal act or is it part of the conspiracy? And the way you determine that is it foreseeable? Would it be a thing that you could foresee a person doing as part of the conspiracy? So it's like, let's go rob a bank, well, they rented a car. Is that foreseeable? Yeah, probably, right? And we need a getaway car, or maybe they stole a car, right? They stole a car. We'll make it more clearly illegal. They stole a car to facilitate the bank robbery. Okay, we agreed to do a bank robbery. You stole a car. Is that part of the bank robbery? Yeah, it's foreseeable, so that counts. We didn't, strictly speaking, agree to that, but it's part of it, so fine. But you do something completely unrelated, whatever that would be, then no liability for me. So how foreseeable is it? That's also very standard. Finally, the court warned its formulation should not be accepted as immutable components, but adapted as new cases. So again, these are part of a multi-factor analysis, but these are the sorts of things that we're looking at to determine this. Great. That's all understandable. We know that. That's all established. Fine. Because of the particular allegations here, the international terrorism, are a far cry from standard facts, because, they are. I mean, this is not your standard tort. This is a bit different because Congress created a special law, so it's a little bit different. The court must ascertain the basic thrust of the elements to determine how to adapt them here. So this is a little bit different. So how do we adapt that to this particular situation? To do so, the court turns to the common law of aiding and abetting, under which the case law itself rests. So going back to the original. Fine. At common law, the basic view of culpability that animates aiding and abetting is that a person may be responsible for crimes that they've not personally carried out if they help another commit its completion. However, the concept of helping has never been boundless and ordinarily requires something that does not sweep in mere passive bystanders or those who, for example, simply deliver mail. So again, did you hold open the door for the bank robber? Well, did you know he was a bank robber at the time? Are you a taxi that picked up the bank robbers from the bank? Did you know they were bank robbers? So that would be relevant. We are concerned about sweeping in mere passive bystanders who are just like going about their life and trying to do things from a position where they think maybe they're helping, but they don't know they're helping the wrong person, but they don't know they're helping the wrong person. So we want to make sure that we are, not being completely idiots about this thing both ways. As above, the framework requires the defendant to give knowing and substantial assistance to the primary offender, and courts view those requirements as working in concert, with the lesser one of showing a demand, a greater one of showing the other to establish the conscious participation. So the person's knowing participation is the more important element of the two, because we're concerned, again, about users going about their life doing a whole bunch of things, because people facilitate crimes all the time without knowing that they're doing it. Because criminals don't always look like criminals. They look like normal people sometimes. And if you're just a normal person going about your normal life doing normal things, that's not aiding and abetting, because that'd be really, really dumb. The irrelevant law differentiates type of aid among the same access that is grounded in the common law. The 6 factors of substantial assistance call for the same balancing they've undertaken. So the relevant law is basically just the common law. So fine. The parties therefore dispute about what they must do within the context of this particular statute. The plaintiffs assert that it's the person, while defendants insist it's the act. That dispute makes little difference here because aiding and abetting is inherently a rule of secondary liability. So the dispute you're having is actually the wrong dispute. The plaintiffs say what matters is the person. The defendants say what matters is the act. But this is secondary liability. So neither of those things is what matters. You're both wrong. In this context, liability is only available when someone commits, not merely agrees to commit, the actual tort. So if you're the primary offender, what happens is, did you do it? Not an agreement. Because you don't need to agree with someone else to do the thing, right? I mean, that would be a conspiracy. You'd be guilty of conspiracy. But if you have no agreement with anyone else, then you're just, a lawbreaker unto yourself, as many people are. So agreement doesn't really matter if you're the primary liability. In this case, the law extends liability and limits liability in a way with respect to acts of international terrorism. It's thus not enough to have given even substantial assistance to an enterprise. A defendant must have aided and abetted by knowingly providing assistance to another person in the commission of the actual wrong. Here, the international terrorism. So again, the primary thing we're not concerned about is not even the amount of assistance. You can give lots of assistance, amazing amounts of assistance. But what matters more is knowledge. It is that mens rea requirement. It is important in the law. The mental state is important. The fact you did the act is not enough to give you liability. We got to find the mental state. And here, you might have done a lot of stuff to facilitate, but that's not enough. It doesn't require a strict nexus between the assistance and the wrongful act. There is that foreseeability. So again, as long as it's foreseeable, then fine, but still the knowledge thing. Plus, in appropriate circumstances, a role in an illicit enterprise can be so systematic that they aid and abet all the entire enterprise, in which case you're thinking something akin to RICO. So if your involvement is so deep, so wide, so all-encompassing, then maybe you're liable for all the things. Oh, I had no idea that, my mafioso confederate was doing this illegal thing. We had no discussions, no knowledge. It wasn't reasonably foreseeable. Yeah, well, if you're part of the mafia criminal gang thing, and, you're doing lots of illegal stuff to such a deep level, then maybe you have liability there because you're part of a gang that does lots of illegal things. So this is kind of the idea behind RICO, right? You get deep enough into an enterprise that's deep enough. Oh, I had no idea. I might be the kingpin of the mafia, but this particular murder wasn't authorized by me. I didn't have any discussions. Even if that's true, we don't really care that much because you basically set up a criminal enterprise. You set up crime or us. Okay? And if you set up crime or us, You have agent responsibility for the agents of your crime facilitation. So maybe don't do that. So if you're that deep in, well, that's a whole nother level. Anyways, to summarize the requirements, points to elements and factors articulated by this case and also the common law. The elements are not inflexible, but should be understood in light of the common law because it's the common law. Plaintiffs have satisfied the first two elements, that both ICE committed a bad. So first of all, primary liability. You can't have secondary liability without primary liability. Someone has to be primarily liable for there to be secondary liability. So first question, is there primary liability? So did ISIS do a bad? Well, we think ISIS did a bad. We think that they did a bad. So primary liability, we've got that. That's good. And defendants knew perhaps they were playing some sort of role. So, okay, you got that. But plaintiffs do not show they gave knowing and substantial assistance with respect to this particular attack. So they might know in some vague sense that ISIS uses their facilities, but it's not enough in this particular situation. They didn't have knowledge of this particular attack, and they're not so deep into it that they're part of some sort of RICO analogy. They're a business that they know criminals use, but they also have a lot of lawful business. And there are a lot of businesses like that, to be fair, in the real world. And I'm sure you can think of some if you put your mind to it. There are a lot of businesses that might have a notable percentage of criminals that use it, but they are completely lawful businesses as well. So the fact that you engage in a business that criminals use is not enough if you don't know they're criminals and you don't know that you're facilitating a particular thing. So as long as you're not guilty for aiding and abetting the crime, you might be guilty for some other reason, depending on what we're talking about, right? So again, you might be regulated in some other way, but you're not guilty of aiding and abetting just because you know that criminals in general use your business. You have to know you're facilitating a specific crime or otherwise be so deeply entrenched that we're talking about some sort of RICO equivalent. And that isn't the situation here. Plaintiffs allege defendants helped the ISIS in the following ways. They provide the social media platforms, which are generally available. ISIS was able to upload content and connect with third parties via the content they uploaded. The defendants used algorithms that helped to match ISIS content with users who might like the ISIS content. And defendants knew that ISIS was uploading this content, but took no steps to remove. So they knew that this was happening, but they didn't perform actions to stop it. But that's not typically enough for aiding and abetting because this idea of no affirmative duty. I can know you're breaking the law. But if all I do is fail to act, no liability for me typically, right? I have to do a thing, not fail to do a thing because I have no affirmative duty. So mere knowledge that something's happening and the fact that I didn't stop it, not typically enough. The plaintiffs do not allege that defendants gave ISIS any special treatment or words of encouragement. So you don't have that. You don't have that they did something with respect to ISIS. They treated them, for better or worse, as just a normal market participant. If you showed that somehow they gave special recognition or special encouragement, okay, now you're thinking maybe like a solicitation, right? If you encourage someone to commit a specific crime, then you might be thinking solicitation maybe. So maybe that's aiding and abetting, but you didn't show that. So therefore, none of the allegations suggest defendants associate themselves with this particular attack, participated in it, wished it to come about, or sought by action for it to succeed. Defendants' mere creation of media platforms is no more culpable than email, cell phones, or the internet in general. So again, like the same, and for that matter, just postal mail or courier mail, FedEx. I assume ISIS uses FedEx sometimes for sending letters, probably. So, that's just general business. So, no. Defendants' recommendation algorithms are merely part of standard infrastructure to which the platforms are filtering. So, again, this is may be assisting, but it's only assisting in the same way they assist everyone. They're treating it as a general thing. So it is not facilitating. The algorithms have been presented as agnostic. Again, there's no special treatment. At the bottom, the allegations rest less on affirmative misconduct and more on passive nonfeasance. And that is going to be a big distinction. Again, right? Because there's a huge distinction between acting and failure to act. No affirmative duty. I don't owe a duty to you. So if I know crimes are occurring, my mere knowledge does not require me to do a thing. I can let the crime go on and go on with my life, and there is no liability for me in most situations. Of course, some special people have special duties as established by special law, but the man on the street, not so much. So, no. To impose a duty for the not doing a thing, they would have to show a strong showing of the knowledge, scienter, to use a fancy word, right? Scienter, the guilty mind. The guilty mind, and there is no establishment here. The relationship between defendants and the attack is attenuated. Plaintiffs made no allegation the defendant's relationship with ISIS is different from any sort of other arm-length, passive, and largely indifferent relationship with most of its users. And given the relationship with this particular attack is even further removed, given the lack of allegations connecting the attack with ISIS use of the platform. So it's not even clear that with respect to this particular attack, ISIS used these social medias at all, right? We were just trying to get to them because they're aiding and facilitating ISIS in a general way, which we don't even have that, by the way. And we don't even have that they necessarily used it with respect to this particular attack. So it's even more attenuated. We're a couple degrees removed over here, people. The plaintiff provided no reason to think defendants were consciously trying to help or otherwise participate in the attack, and they point to no actions that would support aiding and abetting. The complaint rests heavily on defendants' failure to act, but they identify no duty. No duty, which is the standard rule. There is no duty. For most people, in most situations, you do not have an obligation to try to stop the crimes. You do not have to try. In most situations, for most people. So, no. Even if such a duty did exist, it would not transform the defendant's inaction into knowing assistance. So, first of all, no duty. Second of all, even if they did, still no. Because it would be too attenuated from the act. The allegations here are not the type of pervasive, systematic, and culpable assistance that would bring us into some sort of RICO analysis. RICO-like analysis, right? If they were persistent enough, systematic enough, culpable enough, right, then their inaction might be enough. Their lack of knowledge might be enough. Because, well, if you've created Crime R Us, the enterprise, well, now you kind of have a duty there, but no one is saying that Twitter's that. So, no. In this failure to allege the platforms do more than transmit information by billions of people, the same way you might via mail, phone, email, or whatever, is insufficient to state a claim. A contrary conclusion would effectively hold any sort of communication provider, or really any sort of provider, period, because I don't know whether or not ISIS goes to Walmart to buy water or not, but maybe they do. And then would Walmart be liable because they're helping the ISIS get the water? That doesn't seem right. So that doesn't seem like a good idea. This would therefore run roughshod over typical liability. Ninth Circuit's analysis obscured the essence of aiding and abetting, framing the issue as turning on assistance to ISIS activities in general, which, by the way, not even that, and specifically not this act. They therefore misapplied the knowing half of the whole thing. So you don't understand what knowing means in aiding and abetting law, which is really weird because this has been around for like centuries, but somehow you managed to screw it up. So, okay. Finally, the Ninth Circuit appears to have regarded the DC Circuit's factors as sequence of disparate, unrelated considerations without a common conceptual core. So they looked at it as some sort of like, these are the 6-factor tests, as opposed to these are sort of benchmarks in the common law. So it's like, oh, these are the 6 factors. It's like, it's not really, these are some factors, but you looked at it a little too strictly. There's one specific set of allegations with Google that Google reviewed and approved an ISIS video as part of a revenue sharing system. But the complaint here adds nothing about the amount of money that Google supposedly shared with ISIS, the number of accounts or videos that were approved, nor does it give any other reason to view the revenue sharing as substantial assistance. So Google might have had some sort of review process, but again, it's a generic process, right? Google reviews a lot of videos, they approve a lot of videos, they give money as the ad share thing to a lot of videos, but they do it in a generally applicable way. Without more, the plaintiffs therefore have not alleged that Google provided substantial assistance, even though, of course, and as notable, it doesn't even relate to the specific attack. So first of all, it's not even clear that Google does it generally, which they don't. And second of all, nothing with respect to this particular attack. So just doubly no. The concepts of aiding and abetting do not lend themselves to crisp, bright line distinctions, which, fair enough, because it's common law. But we have a pretty good idea what we're talking about, right? There's a lot of cases that talk about it. It's not exactly an obscure concept. And you might aid and abet in a way that's different, but we all know what we're talking about. It's not that hard. Applying the guideposts provided by the common law, the nexus provided by defendants is far removed. As alleged by plaintiffs, the defendants designed virtual platforms, knowingly failed to do enough to remove the users, which sounds a lot like inaction. Plaintiffs failed to let defendant intentionally provide any substantial assistance to anyone, much less that it defendantly did so persuasively and asymmetrically that we're in some sort of RICO-like analysis. Plaintiffs therefore failed to state a claim. Thomas decides this for a unanimous Supreme Court, 9-0. So no, go away. We next turn our attention to a companion case, Gonzalez versus Google, which basically comes to the same exact conclusion, but we will discuss this as well for its value. In 2015, ISIS unleashed a set of coordinated attacks in Paris that killed 130 victims, including a 23-year-old US citizen. They sued Google under the exact same law we just discussed for the secondary liability because the US citizen was injured in a terrorist attack, and they can sue. But they're not suing ISIS, they're suing Google and YouTube. So, yeah, the district court dismissed the complaint for failure to state a claim. The Ninth Circuit affirmed in a consolidated opinion that also addressed Twitter. The Ninth Circuit held that most of the plaintiff's claims were barred by 230, but with respect to the direct and secondary liability allegations for Google-approved ISIS videos for advertisements and then sharing the proceeds, they held that these were not barred by 230, but they failed to state a claim. So in this case, the way that they brought that lawsuit, they didn't even bring it very well. So they didn't even properly sue, at least the Ninth Circuit thought. But they thought there would be liability if they properly sued. So they would have allowed them to go back to the district court to amend their complaint, right? You screwed up in your lawsuit. You sued the wrong way, but we find a cause of action exists. Go back and fix it. So they would have allowed them to go back and fix it. The Ninth Circuit, however, not so much, because the US Supreme Court said, whoa, with the go back and fix it thing. No, because even if you went back and fixed it, no. And we're going to solve this now, which we can, because we want to short circuit this. So we granted review to deal with this issue because we took on the companion case. So might as well take this along for the ride, even though it's technically, in the intermediate stages, but because it relates to the same issue, we just decided we'll take it along for the ride. In light of the unchallenged holdings and our disposition in the case we just talked about just now, it became clear the plaintiff's independent 230 claim states little, if any, claim for relief. As they concede, the allegations underlying liability are basically the exact same in Twitter. Since we held the companion case fails to state a claim, this would fail to state a claim. So there's nothing to do here. We need not resolve this as a whole because we think that, the Twitter thing solves the issue. And so not so much, again, by a unanimous Supreme Court. Thus, that brings us to the end of the attention of the case of Gonzalez versus Twitter. And given standard law, this makes perfect logical sense. Google, Twitter, Facebook, whatever, are generic companies providing generic services in a generic way to a generic public. ISIS might be using those services, but Google, YouTube, whatever, doesn't treat them differently. They don't actively encourage them. They don't actively promote them in a way that shows a decision as opposed to an algorithm. The algorithm is agnostic. It just does its algorithm thing. To the extent it is promoting ISIS videos or whatever, it's doing it in the exact same way it would for any other customer. They are not treating them specially. So the failure to act is not a thing because it's not a thing generally. Google and Twitter do not also have knowledge. They don't under standard law. They are just a generic company that's performing a generic service. They have knowledge that criminals use their service, but that's not enough. They would have to do more. They would have to know they're facilitating a specific thing or be so deeply entrenched that they would have universal knowledge, like a mafia boss or something, and they're clearly not that. So basically, that makes total logical sense in the way that Congress wrote the statute. They wrote aiding and abetting without further clarification. We bring in standard law. Standard law dictates this result, 9-0, no muss, no fuss. So we sidestep the 230 issue completely, by the way. We sidestep the 230 issue completely. So this does nothing to further clarify 230. So for all the people who are worried about how this impacts 230, don't worry about it because we've completely sidestepped the 230 issue totally and just decided this under the liability as it relates to the terrorism thing. So not so much liability for the terrorism thing because you didn't aid and abet. So are you responsible for your algorithms? I suppose we'll have to wait for another day. And that brings us to the end of attention of this case.